Welcome back to the live stream. I think we are live. So as the title suggests, this could be quite an interesting live for today. You've obviously realized that there are documents unsealed, but there's more to it than that. There's some things that we would like to talk to you about. And I say we, that's because I am joined once again by our Alan Robert Shaw Esquire. How are you doing, Al? Welcome back. I think we are live. So as the and I think you got an echo. Is that coming through on yours?
Yeah.
Or?
What I am doing is just spoiling the audio because I forgot to mute. Yeah, hello. Yeah, this should be quite an interesting one, and you'll find out why as we talk. Because in terms of how we prepare these, usually we'll just come up with a topic, but we have to be very, very careful about what we say here, and you will find out why very shortly.
Yes, indeed. And before we get to that, let's do some sort of groundwork here. Let's do as Secret McSquirrel says and hit that like button and subscribe and click that bell as well, because YouTube's got this funny thing about not always notifying everybody when videos go live, and indeed unsubscribing some people. So if you previously subscribed, if not enough to ask you to subscribe in the first place, I have to ask you again to check that you remain subscribed, because YouTube does this funny thing of trying to get rid of bots and spam and all kinds of things. So if you check that you're still subscribed, I would be very grateful for that. So thank you, Secret McSquirrel, for joining us as always. And yeah, there's lots of comments coming in. Must show us the floof today. I think she's over in that direction somewhere. We might find her. So no, as I said, a very, very interesting chat, and no doubt we'll go off on some tangents again. Just saying a few quick hellos randomly. I'm not deliberately leaving anybody out, but Fazana, hi, and welcome to you, and obviously a welcome to Alan there for you as well. Coming here from Daniela saying, I presume you're talking about Elaine, was unprofessional during the trial, but seeing how dirty she was playing is appalling. Having read some of the correspondence, yes, I mean, some of it seems quite questionable, but we might come on to some of that a little bit later. Someone else, Rena, literally catching up on what's going on Twitter. Yes, indeed, there's a lot of... Oh, Al, I think you've been upgraded to the Honourable Mr. Robert Shaw now, so Your Honour. Liz has a mega pint of green tea. Excellent. I don't have a mega pint of anything, I'm afraid. Might be nice to have a mega pint of something. Al's got his water there. Hi to Melanie, and hi to Sharon. Coke and chocolate and a catch up on law could be better. I'm just scrolling down some of your lovely comments here. So obviously taking Daniela still subscribed, but just realized that notification wasn't on, but now that's fixed. Yes, good, because subscriptions, although it's a great indication of a channel, doesn't necessarily mean you get notifications, as it might suggest every time. Let me try and get that down. I've been trying to get this arm out of the way so that it's not sort of really in the way. And all the thumbs up, loving that. Please do thumbs up this video. So where are we? And just a quick reminder before we really get into it, if you want comments to stand out, always happy to take the super chats and bring those on screen and talk about those and go on our usual tangents, as we often do. And any problems with the audio and anything else as we go along, please do shout up and we'll talk about those. So a great many thousands of pages unsealed and available. Broadly, those documents that were sealed, usually there's a very good reason, confidentiality or prejudice or something else. So they're either of a confidential nature, so that they're not supposed to be publicly seen, only by the people involved in the case. And other potential reasons are that it could prejudice a jury. For example, if a jury were to see it, they would be, that decides the case for me. And we never want a jury to be just swayed on one point that may not really tell the whole story of the whole case. So for that reason, there are thousands of pages that have been unsealed now. Case is done as far as the judge is concerned. That's it. We're off. And all these are unsealed. However, not quite as simple as that, as the thumbnail suggests. So here we go. So a lot of these documents, well, I say a lot, a few of these documents relate to confidential documents in the UK trial. So we're still comparing UK versus the Virginia trial. Now, in the UK trial, many of you will remember when I talked about the judgment, there was a confidential annex to that judgment in the UK trial. That's because a lot of those were, again, not supposed to be public and remained confidential. They were annexed to filings in the Virginia trial, but filed under seal, which obviously meant they remained confidential. So that raises the question now, given that the UK High Court had ordered that these remain confidential, absent further order of the court. So, without me hogging the microphone, Al, why does that cause us a problem?
It causes a problem because, as Dan says, there is an extant English judgment that says certain information is confidential. And the question is, does that have the force effectively of an injunction? And if it does, also who is bound by that injunction? And to get all just technical for a little bit of background, when an injunction is a court order saying people cannot do something effectively. Sometimes that people must do something, but generally cannot. Sometimes an injunction is specific. It is aimed at a particular person. You know, you want to stop your neighbour cutting down a tree or something. It's aimed at them. But it can also be a general order aimed at anybody who becomes aware of it. And just, I know you all like Latin, so that's the difference between an injunction in personam and an injunction in rem. And a worldwide injunction, the classic example was the spy catcher case, where there was a court order saying nobody can refer to any of the contents of this particular book. And that injunction was deemed to be binding on anybody who came to hear of it. This actually crops up quite a lot with the animal rights stuff, actually, because I get all the stuff for activists. And quite often, one of my most regular clients is, quotes, persons unknown, because they don't know who the person is. And again, that's something that crops up because they've tried to make injunctions against anybody protesting outside a particular shop on Oxford Street. And it's, well, how would anybody even know about the particular book? There was one that said, you can't have more than 6 people gathering. So, well, what if 2 people walk in at once? Who's the one who goes to prison for contempt? So it's very important that injunctions specify both the conduct you can and cannot do in very clear terms, you know where the line is, but also who is bound by it. But the argument here is, well, this is a court order that says there's some confidential information here in a confidential annex to my judgment, and that shall remain confidential unless there's a further order. So the question is, now that we know about that, are we effectively bound by the injunction? And to play it safe, we are assuming on the basis that we are. But then we can talk about what the exceptions are to this. And also, again, to get into the background, why, because injunctions are an equitable remedy, not a common law remedy, there's this theory that equity will not act in vain. In other words, you can't go to court for something that actually has no effect. But the tension here is between, does the court enforce a rule that has no effect just to sort of uphold the law, or does it take a pragmatic view and go, well, and I'm going to let Dan use the fantastic phrase that is used in an article on this.
Well, that was I can't steal credit for that, Al. You told me about that, so go for it. It's a fantastic little phrase. Well, I'll give you the first half. The first half, everyone might realize that the cat's out of the bag, and then that goes back to I believe when animals used to be sold at market stalls, but obviously cats would have been much cheaper than the animal, and therefore they used to put a cat inside a bag, pretending it's the animal because it was cheaper. And then if the cat got out of the bag, then the secret's out, the cat's out of the bag. But then the second half, Al?
The second half is the cat's out of the bag and has gone walkabout all over social media. That was a lovely term.
So, yeah, classic little phrase. So, in very, very interesting legal conundrum here, which we thought would be very interesting, because in a nutshell, we can't really talk about the confidential annex to the judgment, even though it's sort of all over social media. So we can't really talk. We can talk about its existence, obviously, but the contents thereof, we've discussed it between ourselves, and we've decided to, as Al said, to play it safe, because as lawyers, we should be, and arguably, apologies to international lawyers, but arguably all lawyers really should be holding themselves to a higher standard and not going against what is effectively a court order. Now, there are arguments as to whether or not we are entirely bound by those, but the argument is there nonetheless. So there's an interesting point here. So if you come across, I'll give you an example of a case that I can talk about. There's no details. No one will know who it is and what it is and whatever, so I can talk about it. But one interesting case is we took on a client who was involved in a criminal matter, without saying too much more, and we came across an order which is called a confiscation order, which is where they were going through the process of reclaiming money from criminal activity. So any money that was in the name of, belonged to, was paid by, obtained by, and so on and so forth by that person was being reclaimed. And so the order effectively said, anyone that holds any money from this person must surrender it to the authorities who are reclaiming this money. Now, this is where being aware of an order comes in. So if you've never seen the order and you took the money, you provided the services, and on you go about your business, and that's one thing. However, if you so much as get sent that order, or you're shown that order, you see it, you're aware of it, then you are to follow that order, because ultimately it is an order of the court. Now, I'm seeing some comments. I'm aware that my understanding of the cat out of the bag may or may not be correct. I don't know, but that's what I was heard or told some time ago. So if you are aware of that order of the court, you have to follow it, because it's a court order. So another tangent, that some people have rung me up. Some clients have rung me up. They became clients after they rang me up, obviously, and had said, I've just been to court. I've got this court order, but the other party has immediately said, I've no intention of following this order. What do I do? Do they have to follow the order? I thought, well, it's a court order. They have to follow the order. It's not a court request. It's not just a statement of the court. It's an order, so they have to follow it. So being aware of the wording within it, we have to follow that. So that's the first thing. There's other things through these documents that have been unsealed that we can talk about, obviously. But this in particular, even though you can go and find it yourself, we cannot encourage you to do that. And we cannot really just divulge the contents and talk about it. Anything else on that at this point, Al?
No, it's just like I say, it's an interesting thing. I mean, the basic starting point in English court is that it's all about transparency and open justice. So it's very hard to get any material redacted or confidential. There are some exceptions to that. Children in family proceedings, you never identify the child, which of course can have a knock-on effect that means you don't identify the parents. It's not uncommon in commercial situations for financial information to be kept confidential because it's market sensitive information, and also, you can get into ironically things like insider trading because you can find out things. One interesting thing is, if anybody wants to know how the Levi Roots reggae sauce is actually made, the recipe is in the appeal. And that actually happened with KFC. Their secret herbs and spices came out in a court case as well. So it's amazing what you can find in court cases. But like I say, the general position is everything should be public. However, certain material can be redacted, and most of the time it's of no particular interest to anybody, but in high-profile cases it can be. And like I said, there's just this tension between where it all leaks out, because in the modern era, and this happened with Spycatcher sort of semi-pre-internet, but people were physically selling copies of the books and transferring them, and there was this issue where, well, look, it's pointless now. An injunction is pointless. You can literally go down to Charing Cross bookshops and buy this book. What's the point of it? But there is a phrase where the judge said, well, at the risk of the law looking like an ass, and this is the sort of thing that makes it look like an ass, we do have to make this order, because otherwise we're setting up an anarchy, which is if you can find a backdoor way of breaching this order, we won't bother making it. again, that is the tension against, the court will not act in vain. I mean, that's an old legal principle, but it's also a pragmatic one. Court time is seriously expensive. There's waiting lists 3 years long. Should you be giving resources where realistically the outcome is irrelevant?
Also, interestingly, there's a phrase many people won't be aware of and have no reason to be aware of unless you're in court and this happens, which is unlikely in itself. But there's a phrase of getting evidence into court via the back door, as they say. The ordinary way of bringing evidence into court is you follow the procedures and any court orders, and your evidence is presented in the way and in the timely manner that it's supposed to be, and it comes in normally, and so on. If that doesn't happen, you can't then, or you shouldn't then, start questioning somebody else and put something to them which ultimately would amount to evidence, or you at least purport it to be evidence in court when it hasn't been presented as evidence in the first place. So this comes back to evidential rules and, again, the procedures and what have you that you have to follow. So all interesting tangents with the way that courts work, and that they have to work in a certain way. Just to address your kind super chats, Sharon, do you think, we can both answer this separately, jointly, do you think JD will ever have the UK decision overturned? What's your personal opinion? Well, I think now that there's at least the prospect of an appeal, the appeal's not exactly live. There's a notice of appeal, which is effectively saying, we're going to appeal. It's not, I wouldn't say it's live yet because nothing's really happened yet. But now that is a prospect, I think it's going to certainly delay any prospect of anything happening to the UK decision. When that all falls down, this appeal falls down, and it is absolutely finite, nowhere to go whatsoever, then we come back to where we were before. And I think it really hinges on one of two things. It hinges on the unprecedented action of the UK justice system taking its own motion to correct an injustice in its own decisions, perhaps to save face, as some people might see it, or it would be an action by the parties, and the parties obviously being Johnny Depp's lawyers on his behalf. I don't think they would do that. So I think we'd be left, I mean, I might be wrong, but I don't think they would. I don't think that they are frankly bothered about it now. I think they feel that, and Johnny Depp feels that he's got his name cleared, and so no need to. So we'd fall back to, would the UK courts, the courts of England and Wales, decide that it needs to be corrected? And I think that comes down to, well, how many people say that it should? And I think we've got quite a few signatures now. I think if we push up to, let's say we had 500,000 signatures, which we are some way off, I think if we did, there's a much more serious prospect of that. So we're kind of in this middle ground. It doesn't really answer the question, but I think we're in this middle ground, and there's a few ifs and buts in the way, and a delay of this appeal, a prospect of appeal at least. Any other thoughts, Al, or does that pretty much cover what you think as well?
That more or less covers. I mean, my thing has always been that I think a lot would depend on how, if Brown would push this, and they've always taken the stance of doing the least possible. If it ain't broke, don't fix it, and only do things that are absolutely necessary. As we saw when they actually did the appeal against the counterclaim finding, which clearly, and they actually said, as we predicted, that they wouldn't have brought this but for the appeal. However, as the post-trial stuff is coming out, I think they're sort of let sleeping dogs lie thing. Bearing in mind, this is all about reputation management in a wider sphere. I've moved now more from they would have just left it to actually it might be something they might be considering as a possible option, depending on how things play out in the media and how things are working for their clients. So I think the chances of Depp being interested in trying to overturn the UK verdict has increased somewhat. I mean, I think a lot will depend on how things are playing in the media, and if there is a narrative that comes out, and especially if it played a part in the Virginia appeal, that, the UK judgment is very significant, that might be a way where they go, actually, we now need to do something about that. So, we shall wait.
No, absolutely. I agree. And I think it's an interesting point, because from Camille's interview saying they obviously Johnny Depp would have left it if she didn't appeal, but they've now thought, well, strategically, morally, ethically, everything else, they've followed suit to appeal the adverse decision against him as well. So yeah, interesting that might follow suit for them to rethink and think, well, okay, let's revisit the UK decision then, and let's lodge that application to reopen. It's a very narrow rule in the civil procedure rules, but the rule is there for a reason. Courts have commented previously that this rule is here because sometimes things are wrong, sometimes they need to be corrected. So I hope that provides some fertile answer to the question. MindLab Matt, thank you for your super chat. That looks like a business there, so do check that out if that sounds of interest to you. Is there a certain rank of officer, and what with the rank of officer I can ask with regards to make a complaint about the police? The chief constable. If your complaint is serious enough, it's always addressed. It's like orders for disclosure are always addressed to the chief constable. I mean, obviously it's not the chief constable that deals with everything, but it's in his or her name, and so when it falls to us as counsel to draft orders for disclosure and things like that, and so all of these things we address it to. It is the chief constable is ordered to produce this disclosure, and if not, to attend court and explain why. I always find that wording fun to write somehow. It's if they fail, the chief constable shall appear in court to explain why this disclosure's failed. I always find that interesting.
I always like show cause why we should not do something horrible, because when it's a case, if you get an order saying attend court to show cause, that means you're already in trouble, and you're basically arguing why you shouldn't be in quite as much trouble.
So yeah, no complaints to the chief constable. I mean, it's not don't get it under any illusions that it's the chief constable is going to ring you up. I mean, it wouldn't be unheard of that chief constable jumps in and gets involved. Can, of course, always do that, but don't bank on it. It's likely someone in their stead. But that's what I would do if I were making that serious. Thank you. Sorry, forgive me, I didn't thank you properly. I put it on screen, but thank you, Stonehenge, for your super chat as well. Really does help us to keep going here. And Rena Fagel super sticker, thank you very much for this. I read these out live, by the way, so if anything comes out funny, it's because I haven't looked at it and read it yet. I just, as Al said the other day, actually, it's just something of a transient nature of this live show, as it were. So it's all just live and on screen. But Lemon character from Baby Lemon jumping in the air to do a high five. I'm not quite sure what that's in reference to, but that, thank you. I'm sure someone understands that. Any ideas, Al?
Is it so? Because one thing I did find out recently was when people were doing like verbal descriptions of pictures, and I thought that's a really strange thing. And one of my friends, she always did it, and I said, "Why are you doing that?" She said, "Well, don't forget, there's lots of visually impaired people, and they are just listening on a reader. So basically, they are getting the fun of all the memes. I always write what the meme, what the picture is actually showing."
Oh, fair enough. Yeah.
I like that. So maybe it's something like that.
Yeah, maybe so. That's interesting. I think there's another. I'm just going through the super chats here so I don't miss them out. But Stonehenge Mac, do you think the Sun newspaper will pay JD in an out-of-court settlement to stop adverse publicity? By the way, great coverage, Black Belt. Thank you for thanking me for the coverage and for watching. Do I think the Sun newspaper will pay? Well, many of the newspapers, I'm not going to say the Sun specifically, but many of the newspapers do pay out-of-court settlements fairly readily. I think I can dare to say, because they are in the business of news, and sometimes it's wrong. And so when it's wrong, they generally, not always, they generally try to resolve it without going to court. This is a strange one because it's been to court, got the decision, but then it went back to court against a different defendant in a different jurisdiction, and albeit the same issues, and the claim was different. So I don't know. I think it's so far removed that I think I can't see it. I can't see that really unless. No, I can't see it. Al, do you think?
No, there's no mechanism for them to do that. There are no proceedings live to settle.
No, there is nothing to settle.
Yeah, and also I think there's a pragmatic thing of why would they need to do it. It's not like they're being asked to do it. Also, they'd never do anything like this publicly. As Dan says, people settle out of court all the time for pragmatic cost reasons. However, there's usually it's done very, very discreetly. I mean, I've explained before about this, reading a statement in open court situation, which like reduces the damages because it's a big mea culpa. But newspapers quite often take we'll spend £1 million on defence, but not a penny for tribute, sort of thing. That this is quite common in litigation where, yes, disproportionately, even though we'll win this case, we'll be out of pocket. However, we need to sort of encourage the others and send a message that it's not worth suing us. So if people thought, oh, hang on a second, if I bring a claim, the paper will always give me some money to go away. They just don't want to establish a reputation for that. So that is something to bear in mind.
Yeah, quite right. No, I agree. And there's, I've been involved. I've represented clients against newspapers, and fairly quick. Actually, I'd probably say they settled quicker than anyone else in my experience. Because settlements generally take a long time, but with newspapers it tends to be, okay, yeah, we accept that was wrong. What do you want? How much do you want? And it really as quickly as that usually.
Well, they're very aware. Nobody's more aware of the Streisand effect than media organisations. So the quicker this gets settled, because there's a saying we have in defamation, which is today's headlines are tomorrow's fish and chip papers. And it's the quicker you get something dealt with, the news cycle moves on and everybody's forgotten about it. So, you might say, such and such newspaper admits that they defamed me and they got it wrong. And it's like, yeah, but that was on page 15 in a little retraction and you've got your money, go away.
Yeah, exactly. So I think that's what we think about that. So thank you, Stonehenge, for the super chat. There are one or two more. We'll come to those first. Thank you, Captain Dunsell, if that is your real name, for your kind of generous super chat here. Those comments, those who did not believe in comedy, you now believe in this is something. Oh yeah, so I think that's aimed generally at everybody else that's listening and or watching, feel free to comment in response to Captain Dunsell. If you did not believe in karma, do you now believe that that's happening? Well, I'm going to be the lawyer about it here and say, well, this is a legal process. It was, this might upset a lot of people, but I'm going to say it anyway. Amber may well believe a lot of what she says. She may well believe every word she's ever said. She may genuinely believe everything that she's said in these allegations and so on. Doesn't mean she's right. Obviously, the first bit of that, a lot of people may not like to hear. But a mistaken witness can be a convincing witness, albeit she wasn't obviously not convincing in this case. But some witnesses can be convincing and still wrong. So she may believe what she said. But that said, a lot of people will think that yes, you're right, Captain. A lot of people will think that this is karma, and it's all going around. But I'm going to be the lawyer about it and say that this was essentially a process, a legal process of challenging statements, allegations, and the underlying claims of defamation and so on. Those have been heard. Those have been decided, and we have these. Albeit two contradictory results, we have them nonetheless. but feel free to respond to that. Unless, Al, you've got comments on that, I will move on.
No, I've just remembered something that I meant to mention to get back to the court documents point and what you can refer to. One thing that's, and this might be very relevant to some of your viewers, where if they're involved in court proceedings and they want to tell people. Now, you can, generally speaking, publicise documents in court proceedings because it's not a contempt of court, nor is it defamatory to give fair and accurate contemporaneous reporting on a trial. So you can blog day to day, or after a trial, you can sort of say what happened and reveal the document, so long as it's a fair and accurate, because remember, you might well be repeating, especially in a defamation case, you're repeating the allegations, but then as long as you say, and they were dismissed or found to be not true, or what sometimes hurts people, or they were dismissed because of technical grounds. So you can effectively get defamation in there, but cover yourself. But there's a general rule under the civil procedure rules that documentation produced in one set of proceedings cannot be used for any other purpose. And that's because the rules are quite strict about disclosure, what documents you've got to hand over. And the idea is that you can't use litigation and go, oh, wow, I've got my hands on all these documents. This is great, because now I've got this, I can actually sue them for something else. They'll say, well, no, that you'd have to start a separate procedure and get separate disclosure, even though you already know what it is. But yeah, you can't sort of trot off to another court and say, I've got statements in this other case, I want to use these, or I've got this disclosure from another case, I want to use it. It's all very discreet, one set of disclosure and one set of statements per case. I mean, that's not to say that there aren't ways around it that you could apply in the other case and say, I want exactly the same disclosure. And of course, you'd probably be getting the same witness. If you could get the same witness statements, you could use them again. Or if somebody didn't give a witness statement or was contradictory, you could actually use the statements in the other case then to prove prior inconsistent statement. So it all gets a bit complicated and technical, but that's just to say, just to remind people that the mere fact that documents are publicly available because they're being used in a court case doesn't mean that it's a free-for-all.
No, absolutely right. And just thank you to Sharon for your kind super chat there. We really appreciate it. We enjoy talking about the law to you guys. It's sort of, we're at that age now where not us, you understand, like in the age of technology and internet, where we can talk to you about this, which it's just it's a fantastic place to be. So we are grateful for the opportunity. And likewise, Kathy, thank you as well. Thanks to you as well, Alan from Kathy Richardson. Thank you, Kathy, very much for your kind super chat. So I'm just going through these to make sure that we've not missed any out. There are one or two more. If I do miss any, just shout at the mods and they will certainly get my attention. They've got my mobile number, so they can definitely ping me up if there's anything that we miss. But Sharon, have you ever known a Crown Court trial halted after the first witness and then rearranged? It could happen, but I would say if it's got to the point where you're in court and the witnesses are there ready or supposed to be ready, or at the very least the prosecution's begun, it would depend on why it's then suggested that it's to be rearranged. It could go either way. I would say if it's got that far, as the saying goes, justice delayed is justice denied, for the defendant, that is, obviously, and potentially for the victim as well, so the complainant as well. So the judge would probably, in fact, we've had one recently, something similar happened where the judge just orders the prosecution to continue, and if they can't continue, then invariably they'll offer no evidence because it's not ready to present. But if it's not ready by the time of trial, given how long things take to get to trial, I think that's telling of lots of things and failures in the system, unfortunately. So that's where we are. But I think by experience, judges might well just order the prosecution to continue, and if they can't, then it's effectively the judge. What would happen then is the judge would direct the jury to return not guilty verdicts on all counts, and it's disposed of. Anything to add to that, Al?
It depends on why the trial's been halted. I mean, sometimes trials are halted because a witness will say something that blurs out something that's inadmissible. We've had that with people who blurt things out in the public gallery as well.
Mm-hmm.
So usually the judges might take a pragmatic approach and say members of the jury ignore that, that's not evidence. But if it is something so prejudicial, it might actually be a mistrial. There's also just practical things like people being ill. I actually had a trial. We had a 2-week trial on a very delicate matter. The judge was summing up, and the judge disappeared. He got to pretty much the end of his summing up, walked out into the corridor, and he was a well-known sort of chain smoker. So I thought, he could have waited 2 minutes. He's almost at the end. And we sat there, and about 15 minutes later, he hasn't come back in. And we're sort of just sat there, and eventually the presiding judge comes in, sits down, and goes, "Oh, members of the jury, could the usher just take the jury away?" And it turned out he'd gone back and he'd had a heart attack backstage. And of course, then there was a decision: do we have to rearrange this trial? I mean, it's a private paying client, so it was very, very expensive. It was a sort of a trial. It was a historic SA abuse trial. So obviously it was very, very delicate for the witnesses. I mean, they'd grown up a bit now, but they were still only in their sort of teens, early 20s. So they'd have to give very traumatic evidence. And we actually said, well, we've actually got all the factual summing up. The judge has summed up all the facts and all the relevant law for this bit. We were literally just at the members of the jury, you may have heard of such a thing as a majority verdict. Just standard direct. We said, we will be happy if you just put that. Because both the prosecution and the defence, we did not want to lose this trial. And the presiding judge said, I appreciate what you're saying, but I just don't think that's the power I have to sort of effectively substitute a judge.
Wow.
What is in the middle of a trial? And basically that had to go off, and 6 months later it was rearranged. And I know it sounds awful. When we were doing like the directions for listing, any chance of a judge that's got more than a 50% chance of surviving to the end of the trial?
Dear.
The interesting thing is you can actually claim from the Lord Chancellor's Department for waste costs for not providing a
judge that survives the trial. Wowzers!
It's about £1,200, and this has probably cost the public 30,000 or something.
Yeah.
So, but yeah, I mean, trials do sometimes just have to be abandoned, and if there's not been a terminating ruling, I mean, if as Dan says, the prosecution offer no evidence, that's it. That's the end of it. We have the old double jeopardy thing in this country. There is an exception to double jeopardy, but it's incredibly rare. So, if there's been a sort of, quote, a terminating ruling, that's the end of it. But if it's just gone out because the witness has said something wrong, or there's been a mistrial, or somebody's blurted in the public gallery, or literally just for practical reasons, somebody's been ill, trials do get rearranged. But as a judge used to say to me, and this was back about 20 years ago, so adjust for inflation, I would say, if you're on it, if we could just have 5 minutes. Mr. Robert Shaw, it costs £30 a minute to run a Crown Court. Will you be recompensing the taxpayer? And you sort of go, look, trust me, 5 minutes now might well save like 2 weeks because we've just seen that all the witnesses have turned up. So we might suddenly be asking you to put the plea again.
Indeed.
Charge again.
Carmen Chapman, thank you very much for your super chat. If JD didn't appeal, would he have to pay the Amber the $2 million? I heard that he. Well, effectively, if he doesn't appeal it, then it stands. So the only way around it is to appeal it, and to set that aside. So that's fairly straightforward. So you heard correctly. Another super chat here from M, if that is your own name. Thank you for your super chat. If most papers unsealed, what orders say don't discuss? So this comes back to the top of the video. So it's not so much as an order within the unsealing of the documents that said don't discuss. It's not even an order as such. I'll be careful how I word this here. It's wording within the bit that was confidential to the original UK judgment. So we had the original UK judgment, and then a confidential annex, which was pointed at by that original judgment. It said, there's this other bit, which is confidential. And it's within that says, this is confidential. Absent, i.e. without further order of the court. And there's been no further order of the court. It just so happens that was filed confidentially by the parties in another jurisdiction entirely, and has been unsealed by that jurisdiction. The mere fact that it then might make its way around the internet to other people is not here or there. What we are saying, our view, at the moment, at least, and this is, it's open to challenge. Most of these, just as the judgments are, they're open to challenge. But our view at the moment is that we are not really free to just talk about it, reference it, read it out, and put it on screen, because there's no further order of the court. So I hope that makes sense, because that's what we found to be an interesting point to talk about.
Yeah, and this has come up in the age of social media. I mean, you remember all the sort of footballers having affairs scandals where they used anonymized initials, to identify people. And of course, you could just like Google an Irish newspaper, or as somebody said, what's the point of an order that stops at Hadrian's Wall? In this day and age where you literally can just go online and find out in seconds what the confidential information is. But the courts basically, privacy and confidentiality is deemed to be worth protecting. There are obvious reasons for that. So the mere fact that it might not be a perfect solution, or it might even be a futile solution, does that mean you just give up on it? And we don't do that in other areas of law. We don't go, look, people still go out and murder people, so let's not decriminalize it. The mere fact that something, because there's this appeal to futility that people use. There's no point doing it because it wouldn't make a difference. But that is a tension that the courts themselves recognise, that they want to uphold the integrity of the law, but at the same time they need to be pragmatic about it. And it is always a balance. It's like with injunctions and super injunctions and things like that.
Yeah, and this is not a super chat, but picking up on what we said, what I said, justice delayed is justice denied. Public records, I can tell wherever dropping does many members in sometimes 18 months cases, people lost access cards. Yeah, absolutely. So I mean the delays in the system are, well, they're horrific, let's put it bluntly. The delays at the moment are absolutely horrific. In England and Wales, there's something in the region of 60,000 cases in the backlog. And they, even a simple theft can take years to get to court. But some people will just think, well, it's just a simple this, simple that. But if let's say you're in the process of obtaining a mortgage or whatever it might be, anything that's got that little box that says, do you have any existing or pending prosecutions or convictions or whatever, you can't check that box for as long as that's over your head, and that might be for 2 or 3 or 4 years. So that's quite significant, in fact. We've had lots of clients that have had things like this hanging over for a long time. So it can be really significant. And Star, thank you for your super chat. Video game controller poses triumphantly. Yeah, I'm starting to get this now. Video game controller poses triumphantly in between the words critical hit. I'm starting to get these now. I'm catching on.
I'm just going to mention, speaking of super injunctions and privacy, I actually was involved in a super injunction once, and I can't really go into details by definition as to what it was. But we succeeded in getting it, but there were 2 weird things about this. The first was we got it, and then the solicitor said, "That's brilliant. Can you write us something up for the website?" It's like to say we got it. It's like, no, you seem to have missed the entire point. But the most annoying thing is, because it was an urgent thing. I mean, imagine super injunctions are where not only do you need to stop the information being leaked, you need to suppress the fact that you've even applied for the injunction, because people will be able to put 2 and 2 together and go, right, we can see if they're this and things. But because I was down here and we needed to get to the High Court in London very quickly, I had to farm this out to other counsel and said, so I prepared everything and said, here's the application, here's what we do. All you've literally got to do is pitch up at the court and say, this is what the application is. And he went, it's brilliant. And he arranged it. And then the judge said, that's fine, I'll do it over the phone. So basically, I farmed out $2,500 worth of work to some other counsel. and then he just had to ring the judge and say, did you get the facts?
Wow. Talking about money and money spent, money earned, and things like that. So I was at this reasonably complex appeal hearing. Now, appeals, as we've discussed in many videos, are very rarely successful. So I knew pretty much this was going to be refused from the off, but I gave it a good shot. And I had 4 or 5 different grounds to try and argue this appeal in. And I remember actually, even before I walked in to court, my laptop had just frozen and then crashed, having got all the papers and everything else. This is one of the downfalls of trying to work electronically, but I'd got everything ready, various different files and PDFs and all the rest of it. And I was just called in. Mr. ShenSmith, are you ready? Yes. Walked in, laptop crashed. As the judge then said, yes, let's hear you. So I stand up. Your Honor, my laptop's just crashed. So whilst it reboots, I'll give Your Honor an overview from memory. And so I explained all these points, and then he said, yes, I see. I've got your skeleton come through. Obviously, it sort of filtered through. My laptop came back on. He said, which of these points are you seeking to appeal this on? I said, all of them. And so we were there most of the day. But the point is this. So I think my fee for all of that, the preparation and the hearing and everything else, I think was £1,000 plus the VAT. And as I learned later, my opponent had the same fee to oppose the application for permission to appeal, but didn't have to say a word. Not a single word, my opponent. So it was literally all down to me. So obviously had to turn up, be prepared to argue all the points. But I worked through them with the judge and ultimately found against me anyway. So there wasn't really much. Obviously, they're not necessarily required to attend even, but she did anyway. My opponent, that is. But not a single word need be spoken, and got the same fee. So I thought that was slightly unfair, but that's the name of the game.
We've mentioned before that judges will often ask counsel to draft the order arising from their decisions.
Yes.
And add something, and it's only directions here, but it was very, very complex directions with lots of technical stuff in there. But, I was sort of sat there, and the judge had said he would do the order. So I thought, great, I don't have to do anything. And then we got to the end, and he said, that's great. And then my lovely counsel on the other side said, well, would it assist Your Honour if counsel were to draft the order? He went, well, I was going to do it myself, but that is very kind of you if you're volunteering. And, yes, no worries. And then he sort of does that, and he goes, as a representative of the claimant, I believe carriage of the order falls to Mr. Robert Shaw. It's, cheers for just dumping me in now.
Thanks, exactly. Thanks very much.
I'm going to have to be ringing you up now to say what happened. Because like I mentioned before, that you do this sometimes. Yeah. You'll sort of say, yes, of course we'll do the order. And he'll go outside and go, what happened? Who won? Because sometimes they are very, very complex.
Yeah, exactly. Very, very complex. It's Joe McKinley. Thank you very much for your super chat. Well, who has the right to apply for a super injunction over a basic injunction? Do we get a choice, or is it specific circumstances? And how would you begin? Interesting question. So I always like to start at the beginning, really, and say, what is it that you're after? Because what is it you want to injunct? Well, who is it you want to injunct, and from what? From doing what and where? And a super injunction, obviously, for those that may not be familiar with it, a super injunction is essentially binding on everyone everywhere. No one is allowed to do this or that or whatever it might be. So it starts with what exactly you're looking to get an injunction on, and against whom. If it is against everyone everywhere, Al, anything specific that you can think of distinguishing between super injunction
the key distinction is that with a super injunction, the mere existence of the injunction itself is injuncted, and you can't reveal it. I mean, you could go along and get an injunction. Say you've got an employee who goes AWOL and takes secret information. You're worried about them leaking commercially sensitive information. Mm-hmm. You can go to court and say, I want an injunction saying they cannot publicise this information. Now, in that case, it'd be a standard injunction, and there would probably be, it would be revealed in court who the parties were, XYZ Limited, and somebody who people might know is one of their employees. And it would probably say something like, an ex-employee is trying to go away, and I am prohibiting them from releasing this information because it's confidential. Because it's all you need to protect is the information. Mm-hmm. Nobody's going to get anything out of knowing that there's, you've been in litigation. Yeah. However, say it's a blackmail case. What if it's a blackmail case? And the mere identity of the parties. So, I would like an injunction to stop somebody revealing some compromising information on me, and I bring that in my own name. And people are just going to go, wow, what have you done? What's the secret information? Because the thing in a blackmail, it's rather weird because you cannot injunct in defamation because you can't injunct untrue allegations, but you can injunct true allegations. That's the difference between defamation and confidentiality. So the mere fact that you are applying for the injunction and the judge grants it means the underlying material must be true. So all that reveals is that I have sued somebody who's trying to blackmail me because they've got some dirt on me, and they genuinely do have some dirt on me. And it's
true, yeah.
So you go to court and say, I would like an injunction to stop this blackmailer, but I'd also like nobody to know that I am being blackmailed. And that's what a super injunction is.
And so just to pick up on Joe's follow-up to this question before we move to some of the unsealed documents, not the ones that we can't talk about, the ones that we can talk about. From family coming near my home, well, it's not a super injunction. This is different. This is oddly enough, a civil restraint order is something that is pinned to a criminal prosecution, but in family cases, the equivalent of a restraining order we call a non-molestation order. So that applies specifically to family members and relevant people. So if it were family members and they were posing some risk to you and you wanted to restrain them, or you wanted the court to restrain them from coming near you and doing things like that, that would be a fairly simple order of the court, which if you have some evidence to back up why you're concerned, the court does it quite readily, to be quite honest. But the best suggestion to you, not advice, you understand, the best suggestion is to do it in person. Fill the forms out and go in person. And the best way, from the best explanation for that I've heard from a judge so far is, well, if you want us to take it seriously, they would be doing it in person. And that's quite right. If you were that scared of somebody, you wanted the court to order them to stay away from you, you'd go into the court in person as opposed to sending it by post or by email. It just makes a lot more sense. So hopefully that answers your question there. So let me turn to there was one interesting thing that we're going to touch on briefly from these unsealed documents. Let me see if I can get the correct window coming on screen. Yes, here we go. Very interesting thing I thought came out of here is this. It's in document 29 that was unsealed on page 17, essentially, which is Elaine trying to, this is obviously in the Virginia trial, trying to exclude from evidence everything to do with Amber's pledges and donations. And it's interesting that with all what we've said as pledge versus donation, it's interesting that the two are specified within this document. So should be excluded. This evidence should be excluded. Evidence of Amber Heard's pledges and donations to charity should be excluded. Now, I've said before that I think, at least in my view, my opinion, you understand, for any defamation lawyers listening, that in my opinion, based on all the facts and the evidence here, my view is that she came very close to the line of being professionally. Choosing words carefully, at the fringe of her professional ethics, because she knew, in my view, the truth behind all of this, and that's proven here by the very fact that she's trying to exclude these documents here. And on the basis, as you can see here, on the basis significantly, there's nothing to do with whether or not Mr. Depp abused Ms. Heard. Yet the linchpin of virtually every effort in third-party depositions and in the press, and to discredit and suggest that she's not fulfilled the entire amount of the pledges, she's a liar, and therefore the jury should conclude because she lied. Blah, 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 blah. So all of this essentially saying this makes her look really bad, and he's trying to use this to make her look bad in light of these accusations. And there's an argument here. This is precisely the type of collateral issue that should be excluded. There is an argument there, but as I've said many times before, it does largely come down to an argument over credibility. And then we go over here. This bit. Well, Mr. Depp argued in the UK proceedings that her allegations were motivated as an insurance policy to build a dossier, neither of which related to the $7 million pledged to charity. Sole motivation for claiming abuse, as alleged by him in this litigation, is to further her career. Well, that's interesting because her own words were saying that she was lending her voice to this cause. And so, again, in my view, she was. It was quite clear that she was trying to further her career. I don't think that's really in dispute. Based on what the jury came back with, that ties the two together. Again, it's based on what happened. Before I move too far through that, any comments on that? First of all, Al.
Yeah, I mean, there is always this thing we can come on to sort of the professional conduct aspect. I mean, I've always been very, cautious because I will never criticise another lawyer generally for their performance in court.
No,
because I know how hard you're bound by your client's instructions. I mean, you can point out and say, that could have been done better. But acknowledging that there's lots of things in, my practice where people could quite point and say you could have done that better. Mm-hmm. And we use these as examples with the new barristers. So there's nothing embarrassing about not, making mistakes in court. Well, it can be embarrassing, but it's inevitable. But it's just pushing things. Now, this particular discrete issue, it's an interesting one because they don't acknowledge that it's untrue. But what they are arguing is a test that we use a lot in court with juries, which is the evidence more prejudicial than probative? Mm-hmm. So yes, the evidence may go to an issue in the case, but that's outweighed by the fact that actually a jury will be so outraged by something or may put too much weight on it that isn't actually strictly relevant to the decisions they have to do. So this is effectively that's what they're arguing here. So they're not saying, yes, she lied. They're saying, oh, well, they may think she's lied. And they seem to acknowledge a jury may well think that there's more weight to this than there actually is. And especially because at this stage they would have known about the UK judgment where the judge did put a lot of weight on this issue and the fact that the donation had been made. I don't think that was determinative necessarily, but they did put a lot of weight on it and said that goes to, not credibility actually, they said it went to motive. Because again, to get hideously technical here, generally courts like trials to focus on the actual issues in the trial. Indeed. Now, obviously, the credibility of the witnesses plays into that. But what they don't like is effectively mini trials on who you can believe. So the general rule is, if you put to somebody, you are lying about this, and they say, no, I'm not. Now, you can sort of point it to previous inconsistent statements, but if you're trying to point to just general credibility, you're not actually allowed to put any other evidence in. You can say, I don't accept that. We still say you are a liar because of this rule about putting your case. But the courts don't say, we're not going to have a mini trial on every single witness about whether they're believable or not. The jury can look at that they can see them and they can look at if they're consistent with the other witnesses in this case, the other evidence in this case. We're not getting into what's happened in other cases. But so then you get into the argument about, well, is this evidence in this case or is it irrelevant? And that's what this entire motion was about. And in the end, the judge said, I'm going to allow it in because I think it goes to a core issue here, which actually was, again, it was more about motive, because it was like, what's the motive for lying? So had it been a straight credibility issue, I think a judge might have said, that's not going in. because you can put that point to her, that's fine. If she says no, well, we'll leave it. But because effectively your case is that this is somebody who is inherently, not just in terms of how they're dealing with the answers to the questions, they are inherently dishonest and incredible. Therefore, it slipped in that way. But it's one of those very fine lines. But it's interesting to see what arguments they ran in the background about admissibility, and how indeed that did play out in the actual trial when it was in or it wasn't in.
Yeah, and interesting, that was part of a number of different things, such as various reports, and this one document alone was 1,000 pages, with various different arguments back and forth, and as you said, Al, it ultimately this issue obviously went in, and the whole argument went in. I just found it was one of those. I mean, for me, it was really pivotal, because for me the credibility aspect was really significant, because if that, I mean, there was this what was purported to be a juror speaking out. And I say purported because there's obviously no proof that it was actually a juror. It probably was. I think it's unlikely someone's going to risk, impersonation and, the potential consequences of lying about it. But let's say it was that, then this was one of the things that they said. I think that shot her credibility. It could have been that brought the whole case down. We'll never know, at least until a year later, and if anyone talks about it in any great detail. But it could well have been that one issue there, and this is why these underlying and background arguments that we now see that were all under seal. Like I said, I'm scanning through this. Like I'm not. It'll make you dizzy if I'm showing these on screen, but I'm scanning through the hundreds of pages here. Like as I say, in this one document alone, there's 1,000 pages, and there's transcripts of the hearings, and there's emails back and forth, and I mean, some of the I won't bring these on the screen because I've got some people's personal email addresses and things like that. But some of the emails back and forth are things, I've not even had the courtesy of a response to this email, despite providing, the information requested, and so you mentioned earlier, I think before we were on the live chat, Al, that some of the emails back and forth show just how heated this case got.
It is. I mean, I've actually sent you something in the messaging, a quote that I like from a judge in a recent case about this, and I don't know if you can bring that up. To say that.
Is that? But my to me as a message, right. You mean?
Yes. Yeah. Just to say, there is 6,600 pages of unsealed material, by the way. So it's going to be like finding the Dead Sea Scrolls. People are going to be crawling through these. And we know there's 6,600 because we know it costs 50 cents a page to get them scanned, and we know the person have to pay for that. Although everybody did actually crowdfund it. But yeah, there's a lot of very interesting material. But while Dan's finding that, one thing to remember is that what you see on the actual trial isn't usually what's going on in the background in terms of the contentious nature of the proceedings versus the slightly usually more cooperative nature. I mean, one thing I would say about the film A Few Good Men that I think it captures really well is how all the lawyers who are absolutely at each other's throat in court are all going to the pub and playing baseball together outside. And this happens over here a lot in trials. Obviously the prosecution and defence barristers will quite often know each other. Solicitors can be a little bit more contentious because it's a large profession, and also they're more identifiable with their clients, so they perhaps have to take a slightly less neutral stance than we do. But generally speaking, you do better work for your client if both sides are being cooperative. Recently, and I just love, and I'll let Dan read this out.
That's what you're talking about, isn't it, Al? Yeah.
Yeah, this is what the judge said about a particular case where they were examining. It was a relatively simple case that could probably been sorted, and this is where all the not normally without prejudice correspondence after the trial was revealed. And it was like, why didn't this settle? Why has this been so? And then they could see the nature of the back and forth letters. And I just think this is a great quote that the judge did.
Yeah. So the problem is that this case is an example of what I would unhappily call bad-tempered litigation, which is regrettably becoming more and more prevalent in English courts. It somehow seems to have become acceptable for solicitors to become mere mouthpieces for their clients to vent their anger at their opponents. Yes, I've come across that myself. It's not enough for the clients to dislike or even hate each other. The solicitors must do so too. I simply do not understand why in 2022 professional trained lawyers who should know how to stand up to their clients and concentrate instead on what is important in the litigation, think it's appropriate to behave like school children in the playground. And it's absolutely right, because the amount of cases that I've been involved with that have been unprofessional at best, and if I were to be uncharitable, I would say bitchy. Between firms, it's just not acceptable. That some of the letters sent back and forth, and you read them, sometimes you just think, this is not the point. The point of it is, and there is obviously a point to the litigation, and there is a serious point to whatever it is you're trying to write about, and they will pull up and argue over certain things, and it's just not acceptable. That's a great quote.
Yeah, well, also, I like the warning to the lawyers there, which is stand up to your clients. So that's not just addressed to the lawyers in terms of, we can't come and say, well, look, we're just keeping our clients happy. It's for you to stand up to them. And again, this is one of the hardest things because, and I think this is part of the problem, you all want a lawyer who will go out to bat for you, but ultimately there's a limit to what we can do. And in the same way we're supposed to give you like advice on the law, on how to conduct the litigation, this is part of it. And this crops up all the time, and I have this with clients where sometimes you're saying, because effectively what they want is you to basically say exactly what they want to say, but put it on your letterhead to give it a bit of credibility. And it's like, if you want to write that letter, you can send it in your own name, that's fine. But
you
I
can
am
send
not
it
as if it's come from me, because that is not me.
Yeah. Quite right. And I think as well that there's got to be an element, whether it's sought or not, there's got to be an element of advice that comes with those letters. If someone comes to me and says, I want you to write a letter and say XYZ, I cannot simply write XYZ and send it off without giving some kind of advice on it. Otherwise, as you said, as this quote said, you're just a mouthpiece. That's not what we're there for. I mean, yes, we are the representative. That's not the same as a mouthpiece. A mouthpiece is, obviously, as it sounds, you are saying what someone wants you to say, but so that they don't have to say it. That's the point. So that there is necessarily an element of advice in it. That there has to be that point of advice. So someone says that, and I will always say, and I'll there comes a point when there's a fine line between following instructions and being unprofessional, and I will fight hard before doing something that I think is against what I think they really should be saying as the professional involved. So we come across that all the time. There is a super chat here I want to come to. I haven't read it in full, but I glanced at it and I think I know what it's going to say, but worth talking about. Thank you first of all for the super chat, Randy. Not contradictory decisions, different litigants, different hurdles for defamation, disclosure and evidence. Yes, I broadly agree. I don't think I've referred to them as contradictory in a sense that this suggests. I think what I mean is they're incompatible, because the underlying issues in the case were the same, but the claim was you are right, the claim was different, the litigants were different, the jurisdiction was different, the disclosure was different. The evidence, the evidence that underpins the claims was different in a sense, but the underlying issues and the facts of the case that led to those two different claims are broadly and in essence the same. So therefore they're not compatible. And so I think the best way to say this is, if it's possible to get, let's say that it was the same litigants and it was the same claim and the same jurisdiction and everything else, but let's say for argument's sake that it was possible to have two separate trials over the same thing. It's not, but let's say that it was. If in one case the rules meant that the decision went in one direction, and in the other case they went in the opposite direction, but everything else being equal, they are clearly incompatible. I think that's my point. Obviously that can't happen. You can't have two claims for the same thing with the same litigants in the same. That's an abusive process. It doesn't happen. It cannot happen, and it's the quickest way to get a claim struck out, to say no. You've claimed this before. It's fundamentally the same facts. So I've literally had questions before now to say, I'm owed £15,000. Can I make a claim for £10,000 to keep it on the small claims track, because that's got cost implications, and then make another claim for the other £5,000? And clearly, no, you can't. It's the same claim. It'll get thrown out before you start, because it's the same claim against the same people in the same jurisdiction, and so on and so forth. My point is, if everything else was equal and you were allowed to do that, and you got two opposing decisions, then clearly those are incompatible decisions. There's a lot more complications in this case, or these two cases, but that's my point. I think they are incompatible, and that's my point. Unless you've got anything to add, Al.
No. I think you've done your forensic dissection of the judgment. I mean, the thing to remember, though, this all comes back to, in terms of when different courts come to different decisions, and also how appeals work. Strange as this sounds, judges are not required to reach the correct decision. All they are obligated to do is come to a decision that is open to them within the rules. Yes. And they have a certain amount of discretion in terms of how they interpret the law, and they have a huge discretion in terms of how they judge facts. It's entirely up to them which witnesses they believe and how much weight they put on evidence. And and if you appeal this, all the appeal court is doing is saying, was your decision within those parameters? An appeal court might well, and sometimes they will openly state this, we may have come to a different conclusion. Yeah. However, we will substitute our views for the views of the trial judge, because that is not the test. The test isn't, did this judge get it right, or even did this judge come to a decision that majority of judges would have come to. So long as it's not a decision that no reasonable judge could have come to, then it stands. And the mere fact that lots of people are going, well, that was some very weird decisions there. However, as long as it's within the range, and this is the same with court cases. And as we've said before, remember, the standard of proof is balance of probabilities. So it could be a very fine line as to, did this happen? Is this more or less likely to have happened? And some people might honestly think one way, some people might think the other way. But the law is binary. There's no verdict of probably. So as soon as it gets 0.0% over that threshold, it happened or it didn't happen. And because of that, you can get inconsistent verdicts from different tribunals. And the law isn't particularly fussed about that, to be honest.
And I think this is a really interesting point in that how people interpret, and this goes for every jurisdiction. It's not just England and Wales. This is one of the things I really do love about law is there are a lot of elements that are truly international, truly universal, and this is where we as lawyers speak of the rule of law. It's an internationally recognized understanding. The rule of law is it is what we say it is. It's what the legislative provisions say that the law is. And there's I think the flu's coming in, and I think to I think the Floof's going to say hello in a minute. I think to help people to understand something here, the court, and this will upset a lot of people, but the court, come here, Fifi, come here. The court is not there necessarily to prove right or wrong. The court is there to hear the evidence presented from the parties and make a decision based on that evidence and based on what's presented within the rules and within the jurisdiction and within the law, not necessarily the truth. And I'm going to have to show you the Floof. So she's come in and plonked herself down here. She sits here very often. So when you're watching my videos in future, you can assume that she's probably sitting nearby somewhere. So she's... Anyway, had to do that. She's got her own channel now, by the way. Like 1,300 and something subscribers. So mods, if you can, link in the chat box, please, or I'll find it in a second. But so I think that's a really interesting point. People think that, you know, the courts are there to find the truth, and you know, we hope that the courts find the truth. We really do. But it's the decision based on the facts, the evidence, and the way it's presented, and the law that underpins it. Anything to add to that, Al?
Well, just that in the criminal sphere, there's the famous quote where somebody objected to a question, and the judge said, I think it was actually a Scottish trial, but anyway, it's probably one of these apocryphal stories that sort of vaguely happened once. But somebody objected. The judge said, "Are the jury not entitled to to hear the truth?" And counsel probably said, "No, they're entitled to hear the evidence." Mm-hmm. And they are different things. I mean, evidence gets excluded all the time, especially in the confession must be excluded, quotes, notwithstanding that it may be true. I mean, the classic example is you can't have somebody on a jury who actually saw what happened, and they're obviously the best arbiters of where the truth lay. But you deliberately go for people who have no background knowledge. So yeah, I mean, like Dan says, we're hoping to get the truth. We're hoping to get justice, and the CPR says the overriding interest is to do justice between the parties. Although then it does actually qualify it by saying, subject to proportionality, and let's not, spend too much time on this. And what's very worrying is the Master of the Rolls recently said, he said basically you've got two types of trial. You can have it quick and simple, but not necessarily particularly accurate, or you can have a more detailed reason thing, but you're going to have to pay for it and wait longer. And he said, I think most people would prefer things to be dealt with quickly than actually get the right result, which obviously did create quite a bit of controversy. People going, actually, no, I think the ideal situation is it should be quick, affordable, and still get the right result. But just effectively saying, a lot of people are just happy with a decision, and it's a very quick and dirty sort of broad brush approach. And yes, there will be some personal injustices, but the system will work better. I can see there's a big argument as to why, especially if you're one of the parties. If you're one of the parties, you don't care that it's a small claim. You want your case to be tried as if it's like Jarndyce and Jarndyce in the High Court. You want the same level of attention paid to your case. But, as always, there are pragmatic and cost decisions. And, the court system is set to provide, quotes, justice in the round, but that can involve some injustices on a personal level, especially when people can't appeal on technical grounds. Might be, well, actually, theoretically you probably should have won, but hey, the rules are the rules.
Yeah, and I think so. The fund, and again, this goes for any jurisdiction, and I think this is why it's been so so complicated. These two trials, but the fundamental point here is you've got one shot to do it properly, otherwise you're on the back foot. And so you absolutely have to ensure that your evidence is presented properly, timely, accurately, and within the rules the first time round. Because if it's not, you run a serious risk of not having the evidence presented that you want to rely on, and therefore you can lose what would otherwise be a perfectly winnable case, and and have what many people would see as a huge injustice because you just simply didn't provide the evidence. And that's what we've got with these two trials here. There's so much evidence, and then, you know, is it relevant? Is it, as Al said, is it, you know, probative? You know, does it go to issues within the case? Does it go to prove those issues or disprove those issues? And is it something that really should be heard, or is it purely prejudicial? I.e., easiest way to talk about this is if you've got a defendant on trial for a particular crime, but they've got a long list of other crimes that they have done, doesn't mean they did this one, and the old ones are nothing to do with the new one. Someone hearing those old ones may well just, and very often will just, come to the conclusion, well, they did all these other ones, they must be guilty of this one, which is obviously prejudicial, obviously not correct. You know, as we say, 4 words to live by: innocent till proven guilty, and that's on every time it comes forward.
I'm just looking for. There's a great quote that the appeal courts are using a lot now. I'm just trying to find which judge used it originally, and they said the trial is not a dress rehearsal; it is the first and last night of the show, and that's that thing that you've got to be ready. Yeah, it's a great quote, but I've noticed that the appeal courts are using that a lot now. You know, and because you can come along and say, look, the whole point is it's meant to be about justice, and now we have something here that shows that, you know, the results should have been different. And say, yeah, but there are rules, and this is this whole thing about the tension between individual justice and the system that works. And the idea is, yeah, you just get one shot at this. And that's why that's why there are civil procedure rules. That's why there are practice directions. That's why there are pre-action protocols. I mean, they do sort of say, we try and spoon feed you through this, although sometimes it can be quite hard. I mean, the practice directions are very, very good. And in fairness, you do have to sort of mess up quite a bit before they just go, that's it. They will quite often give you like chances to amend pleadings, especially if it's done early. The big test for relief from sanctions is, will it affect the trial date, and will it cause chaos, and will it prejudice the other side? If you can sort of go, look, we've put it all right now, we made a mistake, hands up, mea culpa, but in the grand scheme of things, it's not going to make any difference, and ultimately it's about justice, and we do have a good defence or claim, we shouldn't lose it on a technicality, courts will go, oh, all right then, although they might penalise you in cost. Say, get it right next time.
There's an interesting point here, which I want to address, because there are, I think I've got a couple of thoughts that I've probably not said beforehand. So, ensure the judge is not biased. So what we've always said on this is, I would think it quite far-fetched to think that a judge is biased. But that's not to say that a judge might have personal views and a way of looking at something. And so long as that is based on the evidence and reasoned judgment on that evidence, that's precisely what a judge is there for, to judge the case based on his or her judgment. Not to be cliche and no pun intended, but that's exactly what they're there for. We just don't.
I think.
Go on now.
Sorry, Don, I was going to say, I have ultimate confidence in judges not to express any actual biases. They're just trained for that, and also the sort of people they filter to be judges. But there are, of course, unconscious biases, and that's one of the issues. And judges get a lot of training on this about, they get the diversity training, but they also just get general. Here's how we assess people. Here's the psychology of how we make decisions. And judges, in some ways, they almost do have background in, how to assess evidence. However, I think this is one of the benefits of a jury, is that by having a number of people, you average those biases out, those subconscious biases, and you've got more representation there, and you've got more experience, you've got more collective experience. I mean, a judge, a 65, 70-year-old judge may have collected a lot of life experience from trials. Yeah. But 12 people on a jury is probably the best part of 600 years worth of collective experience. And they by definition know more about real life. And also lawyers can quite often get it's useful for us to be able to be detached and in the abstract and look at things, quote, rationally. But that makes us possibly worse at judging certain things than lay people who just use their common sense. And Stan keeps saying the law should follow common sense, and usually it does. And this is one thing we always teach people when they're doing jury advocacy is your case has to be compatible with common sense. You might win on a brilliant legal technical argument that you have to use mental gymnastics with a judge. But with a jury won't say, well, we get all your fancy stuff, and if this, then this, then this. But we can just look at this and go, it's rubbish, or it's not. We can recognise what's going on here. We don't need to get bogged down in the forensic technicalities. We're just taking a broad brush approach, and we can tell who's in the right and who's in the wrong here. And that's what juries are very, things. But juries, again, finders of fact have a pretty much very broad discretion as to what facts they can find. If it's open to, if there's even the merest bit of evidence to them, one person says the car was blue, 500 people say the car was red. They can say the car was blue. That is the very low hurdle that people have to meet when finding fact, and that's why appeal courts will only turn findings of fact if they go, there is literally no evidence here, or the evidence is clearly contradictory. The mere fact that they go, well, all the evidence was one way, 99% of the evidence suggested this, and only 1% of the evidence suggested that. The finder of fact, whether it's judge or jury, can go with the 1%.
Absolutely, and that's why I'm a fan of juries. And you've got to remember, as you just said, the collective experience and bridging that gap between the law, the procedure, some errors of parties make mistakes sometimes. If witnesses make mistakes, and as we've said, mistaken witnesses can be convincing witnesses. So you have to be really careful. That's why I favour the jury system. A lot of people are critical of jury systems and say, "Oh, the jury are not trained." Well, they're trained in life, aren't they? I mean, this is a very serious point.
Yeah, well, they do get assistance because this is parallel to how expert witnesses work. You can only call an expert witness if their area of expertise is something that your average person wouldn't know. So you can't call an expert witness. You can't call an expert witness to sort of bolster somebody's credibility, because that's jurors for that. But also, it's just everyday experience. Then you can't get an expert witness. You might get an expert witness to sort of come along and say about a particular industry or trade or profession. This is how we do things. To give an idea of the culture. But generally speaking, things are left to the lay people. But for instance, they do now sort of in some criminal offences, they will get guidance as to sort of, certain myths about certain offences and things like that. The ultimate decision is still up to them, though. They're told, here's some background, here's what some researchers have found, here's, some common misconceptions, but ultimately it's entirely down to you as finders of fact. And like, the alternative to that is, and people have said, let's have specialist judges in certain things. I mean, and you do get that in arbitration, where you get judges who specialise, like we said before, in the oil industry or in the art world. We have specialist arbitrators. But when it comes to real human beings and real human dynamics, real human beings are the best people to assess that because they live it.
Yeah, absolutely. And I think unless unless it is a really straightforward sort of simple case, and I don't think there's any better way than to reach to a jury to have that mix of experience. But there we are. I can see lots of it's making me hungry now. Lots of people are talking about easy Chinese cooking. See, I'm sort of fortunate. I get to eat this every day.
I've not had breakfast yet, so and I'm cat sitting at the moment, and the cat's had breakfast, and I haven't. So when I go to visit the cat and open a stinky food, then I think afterwards I'll eat something myself. One thing I did notice earlier on, I think it was Anna Karena, if that's your real name, as Dan would say, raised a thing about the McLibel defamation trial, where it was interesting that because which is really showing our age. Some campaigners were handing out leaflets, what's wrong with McDonald's, And that was another thing that backfired very badly, because McDonald's would just seem to be bullying two people who were just, at the very worst, they were annoying hippies hanging outside a McDonald's. But a lot of people thought that they were sympathetic. But the interesting thing about that is, it turned out it was the group had been infiltrated by an undercover police officer, and it was the undercover police officer who wrote the leaflet. And I actually did say in certain other circles where some people were chatting about putting out a press release, I said, "Are there any undercover police officers here? Because they clearly they're really good at writing things, you know."
Yeah.
Should we just get in touch with the Met and ask them to write it? But that was an interesting one, that, because like it had horrible repercussions down the line for people. What's interesting about this, and maybe we should chat about this another time, because I had a friend, and he was an undercover police officer on Operation Julie, you know, the LSD case back in the day, the big one, and he went rogue. He went native, as they say, you know, in the police force, because he did 2 years with them, and just went, hang on, why are we trying to get these are nice people, and he just went completely off on it, and basically ended up leaving the police force and came to the bar, ironically.
Okay, well, that's interesting, because I find that you've probably found this out, but everyone that comes to the bar comes with a story. There's a reason they came to the bar, unless it is, and I don't mean this in any way disrespectfully, but unless it is because, you know, mum and dad said you're either a doctor or a lawyer, go and choose, and that's why they end up at the bar. But if it's not that, invariably there's a very interesting story behind coming to the bar. And very often it's being embroiled in your own litigation yourself. So somebody just down thumbed and didn't like what I said. I'm sorry, but that's it's the truth. You see, I see when those thumbs go down, but like I said, not everyone's going to like what we you know. I'm a lawyer. Not everyone's going to like what I've got to say. But
this is you know. Well, the thing is, it's back to this duty about lawyers generally. You know, we have our duty to the court. That's the primary duty to the court, then to the client. But I like to think, although it's not a formal duty, we have a bit of a duty to the general public. And that's why we do these demystifying things. Because I hate the access to justice thing, and how people are excluded because of, you know, cost and things, but also just the terminology. And there are reasons to use the terminology. We have to be precise about things. But I think it's important to, you know, explain to people what's going on, and you know, there's no great magic to what we do. We just have particular labels on things, and we have some technical, tricky issues. But you know, so do car mechanics. You know, I spend a lot of time on YouTube going, you know, how to sort of, you know, get a starter motor and a Defender working and things, you know, and I am very grateful that people are willing to give their time up, especially as people who run garages who could say, I'm not going to tell you just bring it in and we'll fix it for you for a large fee. And I think we have this, and one of the reasons that I do feel it's okay to criticize certain lawyers out of court behavior, or even in court behavior, not lawyer behavior, is that reflects badly on us. And what we don't want is people going away going, oh, that's representative of lawyers. And I've seen this in the chat. People go, no, lawyers are allowed to lie on behalf of their clients if their clients are lying. Yeah. And it's like, no, honestly, we're not.
We really can't. Yeah. No, you'll get the same reaction, I think, from 99% of lawyers, because there's always 1%, but 99% of lawyers will have the same reaction Al and I just had. Is like, no, absolutely not. It's immediately disbarable if you're caught lying about stuff, regardless your client said so. If you know it not to be true, you can't say it. Yeah. Thank you, Miss Mentats, for your super chat. I think that probably is your real name. Random 15th century barristers were junior counsel equivalent today. Maybe you and Alan could share some more interesting history tidbits. Well, interestingly enough, we are, unless we are Queen's Counsel, we are all junior counsel. Some barristers refer to themselves as senior juniors. And that's right, I suppose. I'm not sure that's an official term, but it's. I mean, I would certainly be a senior junior.
I'm having this very discussion with somebody recently about, because the only official discussion at the bar is junior and Queen's Counsel.
Yep.
But we do have this thing of senior, junior, which apparently I am, which I quite like. I'll be honest though, because I said this is terrible because I said the only grade that counts to me is it's the guideline rates for cost recovery. You know, we've said before that the rule is loser pays, winners costs. Mm-hmm. However, those costs, you can't recover everything. Lawyers can charge their clients what they want, but the other side can't necessarily recover everything. You can't necessarily recover all your costs. If you can go off and have a Rolls Royce service, but the court will say that's fine, but the other side should only have to pay for necessary service. If you want the top lawyers at £1,000 an hour, brilliant, go for them. And they cap the fees that you can recover. And there's tables, and it depends on geography, and Cornwall, of course, is the lowest graded, and London is the highest. But it's also your relative seniority. And I'll be honest, because I count as grade A, which means I can recover the top whack. And that's it. I said that's the only grading I care about is the recoverable rates grading. Because in practice, I could never take silk, vegan, and silk's not vegan. That's my excuse anyway. But I'm just not interested in that. But yeah, it's a very interesting thing. And Miss Mentats, we will love to do some interesting historical trivia. To give you one thing, we've mentioned this before, but the Oscar Wilde trial, the first question put to him by his own counsel was his age. He lied about his age, and then because counsel was under a duty not to support a witness with an untruth, he had to correct his own witness. And in a defamation case, the first thing that happens is your own counsel points out you've lied about something. That is not a good start. And as we know, it did not end very well for Oscar.
I had one exactly like that. There was, and it was more. It wasn't that he lied, but it was so clear that this guy wasn't involved, and yet had put in his witness statement that he knew all about it, and it really clearly didn't, because he wasn't there. He got all the dates wrong, and not just the 16th instead of the 17th, or the 36th instead of the 26th, or something like that. It was just completely wrong. A different month and a different date, and just clearly off the wall and wrong. And so, bearing in mind everything we've said about you've got one chance to get it right the first time round, to get the evidence in, to do it properly, serve it in time, and so on and so on and so on. And we get to court, and the first thing my opponent does with his sort of main witness was to say, first of all, I'd just like to take you to, paragraph, before the witness statement is taken as his evidence in chief. So ordinarily you go to the witness statement, is this yours? Yes. Is that your signature? Yes. Blah, blah, blah. Your Honor, if that might stand as evidence in chief. Before all that, he said, before we do that, can you please go to paragraph 3 or whatever it was? He said, you see where you've put that date? Yes. Well, you actually meant this date, didn't you? And I'm sitting here thinking, what are you doing? And so he's going through correcting the dates, the inaccuracies in his statement. And he said, yes, that's what I meant. And then my opponent then turned to the judge and said, right, with those corrections then, Your Honor, if that could stand as his evidence in chief. And the judge kind of looked at me as if to say, what do you think about that? And I said, well, Your Honor, clearly this is, this was served as it was weeks ago, in accordance with the rules and so on and so on. Anyway, we had a bit of an argument about it, and the judge said, well, I'll note that it was changed, but we'll see where we go. So I thought, okay, fine, all right. So obviously my first questions in my cross-examination were, before we started this trial, the first thing your counsel did was this, wasn't it? You changed these dates, didn't he? That's because these dates were wrong, weren't they? That's because you got these dates wrong when you drafted this witness statement, but you signed it, and so on and so on. When you first signed it, it had these dates in it, didn't it? And these dates were wrong, weren't they? If it was correct and you were there, you would have known the dates, wouldn't you? And just grilled him for 15 minutes on the fact that his counsel had blatantly tried to change his evidence at the start of the trial. Needless to say, I won that case, but it was utterly bizarre. Just, if let's contrast that with something immaterial, which I've done before. Now, if you want to change let's say you want to change your statement of case after it's been served, you need the permission of the court, and so on and so on. So sometimes there's been just an administrative error within the drafting of the document. It shouldn't happen, but sometimes happens, and it says defendant instead of claimant when it's clearly supposed to say the claimant, and no one's really going to argue, that destroys the case because you used the wrong term within that paragraph. So in that case, you stand up, you make an informal verbal application to correct the statement of case. This should clearly say defendant instead of claimant, and unless there's any objection, let the court record reflect that this has been amended, and so on. And it's immaterial. It clearly makes sense. No one's going to object. It doesn't matter. But in my example, it was clearly to try to change the evidence because it clearly wasn't there. I didn't know what was going on. It was just ridiculous. Anyway, I don't know how we got onto that, but getting it right the first time, I think is important, wouldn't you say?
Yeah. I mean, actually, I had a case where it turned out pretty much just before the trial that we'd been using the wrong name for one of the parties. It was a company. Now, this was a case of it was clearly the right party wrongly identified.
Yeah.
And you've got to be very careful about this. If you issue a claim against like a company that's got different companies within the group and things like that, make sure you get the right defendant. There are cases that have gone, no, sorry, you sued the wrong person. But what sometimes happens is you sue the right person, and I say legal person here to mean a company, but you've used the wrong name. But rather than re-amend everything, the judge just said, shall I just make an order saying, prior to today's date, any reference to XYZ Limited shall be read as if it was ABC Limited. And that just saved everybody having to go away and rewrite everything. So it's like, yes, please.
Yeah, no, quite right. So yeah, I mean, sometimes these things are just just necessary to correct, and others, I mean, it's just blatantly. I mean, actually, in my example, it would have been far better to have if the opposing counsel. I can see why he tried to get it corrected, because it was wrong and it did show him, but I think he did far more damage drawing attention to it in that way that led to 10 or 15 minutes of destroying all credibility for this guy, because it was quite clear that he was trying to twist his evidence. But by the by, there's different ways of doing it. But I spot a couple of Superchats. Thank you, Miss Mentats, and I stand corrected. It's not your real name, but no, I don't have time for games, I'm afraid. But there we go. But thank you also to Randy, new facts from discovery of Emperor's litigant. Yes, we will be going through some of these, as many as we've got time for. As Al said, there's thousands of pages, so just as much as we can. Hazel, what just happened? Well, you see, this will
first the Earth cooled, and then the dinosaurs came along, but they got too big.
Yeah, and then they disappeared, and well, some people believe they went under the sea, don't they? But we're not quite sure. But yeah, this stream will be live for at least 24 hours, and then I suppose depending on how it performs, whether it stays live or not. Timing wise, we are an hour and 43 minutes. Don't know what you're like for time, Al, but perhaps another few minutes if people have any remaining burning questions that you want to get in before.
Well, I have a burning question of my own for our audience, because of course we are here to serve you. Now, some of you may remember that another one of those defamation trials we've just got the result back on that, and of course that is Vardy and Rooney. So I don't know how much appetite there is for talking about that. The case itself isn't legally that interesting. However, there are a couple of bits in it to do with how the judge addressed certain lost evidence. And what was also interesting is, from a very technical point of view, Rooney succeeded on truth but failed on public interest, which is something that's all the sort of defamation lawyers are going, oh, that's very interesting, isn't it? And that's an interesting way that the judge approached that. And, you know, really, is that right? And could she have appealed on that? That's real lawyer nerd stuff. The one very interesting thing was, as people knowing this, certain crucial evidence went missing in very, shall we say, dubious circumstances. You know, things fell off boats, things were broken, people lost passwords to telephones, laptops, hard drives crashed, etc., etc. And I did wonder, the result wasn't a surprise to anybody, but it was how the judge addressed all the missing evidence. And what was interesting is the judge pretty much said, yeah, this was a conspiracy, this was deliberately done to suppress the evidence. We thought the judge might just do I'm not going to make any findings as to what happened on the evidence. However, the fact that it is not available cannot assist Miss Vardy. So, basically achieve the same result without pointing the finger and saying you deliberately conspired to suppress the evidence. Mm-hmm. But the judge was, in very couched judicial terms, it still wasn't a sort of, j'accuse type thing. It was just, no, I find it likely that this was a conspiracy to suppress the evidence because she knew it would have come back. And what's really interesting about that is, and I love this, somebody used a case from, now we're saying 1721, the judge thinks it's from 1720. Sorry, we say from 1722, the judge thinks it's from 1721. But what was interesting in that is that was a very old case that somebody relied on, which is a case where, a little bit of legal trivia for you. Back in the old days, a chimney sweep's apprentice found a jewel while cleaning a chimney, and they trotted off to a jeweller's shop and said, "How much is this worth?" And the jeweller said, "Oh, it's only worth threepence halfpenny." And they said, "Oh, well, we'll have it back then." And then the jeweller wouldn't give it back, and they said, "Well, you only found it, so I'm keeping it." And then the actual case turned on who had the title to it. But what happened was when they gave it back, certain things were missing, some jewels weren't there. And the jewellers said, "Oh, well, basically we can't get the person here, we can't put the evidence as to what happened, but we have a really good explanation." And what was interesting, the court said, if you look like you're deliberately not keeping information away from court, we are entitled to assume that's because it's devastating to your case. So not that the lack of evidence is neutral. There is a precedent saying if somebody tries to keep evidence out of the case, you can assume the worst about that evidence, which is a very interesting approach. And that was the one they put in. And they said the fact that she was trying, it's not neutral. It's not that we don't have any evidence in this matter. It's the fact that by suppressing it, you can take into account that means it would have damaged their case. And again, that was an interesting thing, and it just goes to show that's a literally exactly 300 or possibly 301-year-old case, and that played a key part in the defamation trial.
That's fascinating. I mean, I love how what is essentially very, very old law will still come back and influence.
Well, that's the lady Mentat because she said she liked historical stuff.
Yeah, no, exactly. And this is one of the drawing factors, I think. Just very, very old law, very, very interested in old laws, old procedures, and the traditions, and hence the wig, the gown, everything about it. I spot a super chat aimed at you, Mr. Robert Shaw. Let me find it. It takes a minute to come through. I get the ping before it actually comes through, and then it pops up. Here we go. Well, I don't know why it's so small. Let me move it around. I've still got to master this software. Some people have mastered it better than me, but.
Well, yeah, that's an interesting question, actually, because my friend Sam, who's the guy who developed the vegan barrister wigs, because actually vegan barrister wigs are normally horsehair, so we go animal product, won't wear. I mean, but he actually developed. He's developed vegan wigs, and because he's a bit of a hippie, he doesn't look like a hippie. He looks like a proper barrister. Actually, that's why I was trying to avoid having any pictures taken next to him because I just look like I've went through the bins. But they also have produced robes out of recycled material, something like recycled carrier bags or something. And indeed, he did say that they could, because QC's robes and regular junior barristers' robes are slightly different designs as well. It's not just the material. And he said, we could make a vegan silk twig, but I am not applying for silk. It's just not something I'm even vaguely interested in, and also it involves lots of form filling now, and I'm not very good at form filling. As Dan can tell you at some time, the hoops you have to go through to get the litigation qualification. And when you actually do direct access courses, they say, look, just to make sure that you filter people who perhaps might be better with assistance for solicitor, just make the application slightly tricky, because then that will. And then I was trying to fill this form out, and it took me about 6 months to do it. I was kind of. I just remember what you said. Is this just to filter people out? It's like if you can't figure out how to fill the form out, we're not going to risk giving you the qualification. And I think there might be some truth in that, because it is. How many people have that qualification, Dan? It's hardly anybody, is it? And I understand why.
Comparatively, no. And public access you're talking about, yeah? And
no, litigation qualification.
Oh, the litigation, yeah. I mean, I was going to say public access is not that high as it is, but litigation is just. They tell me just over 1,000, but I don't think it's that high. I can't find the actual number. I'm told internally. I can't see it is that high. No, I can't.
They run the course twice a year, and there are no more than 12 people on the course, and it's only been running for 10 years. Yeah. So
I mean, I got mine. I got mine without doing the course because of running the firm and everything else. So. But yeah, I just filled the forms and got authorized. But yeah, I can't see how it can be over 1,000 people. It just doesn't make sense. I think it's more like 300, if that.
I think the last count I saw got 170 or something.
Yeah.
But anyway, that's probably not of interest, or of minor interest of you. But it just goes to show, like I say, we have all these hoops we want to go through. I'll be perfectly frank with you. I do the advocacy training for Middle Temple, and I love that, and that is. My gang, as it were. That's what I really enjoy doing. I love doing the courses. I love, hanging around with the students, but I also like hanging around with the other advocacy trainers. They're a really, really nice bunch of people. And as I've said before, doing the advocacy training really ups your own game, because you're supposed to demonstrate to the newly minted barristers how to do it properly. Yeah. And it really should. Sometimes you make a complete mess of it, and then you have to use that as a learning experience for them, just to show how hard it is. Which again is why I never criticise other lawyers' performance in court. I might say, what they did there was bad, but that doesn't mean they're bad. It just means they made a mistake. It doesn't reflect on them generally.
Yeah. Interesting here, total tangent, but thank you for the comment, Saltstorm007, if that is your real name. But first live stream with the same amount of likes as people watching. Let's see if we can up that, because I know people come and go. Let's see if we can smash the number of likes versus the number of people watching. So we've got 1,300 likes, and so and just about the same as people watching. Let's see if we can smash it before we leave you for what is very quickly becoming our evening. Hello from Shanghai. You must be going through a VPN of some sorts. But no, thank you for joining us, and I'm glad you enjoy the legal chat. I heard a noise then, and I just realised it's the floof behind me. She goes so quiet sometimes because she's sleeping down here that I forget that she's there. Then I hear this noise and I'm just feel like something's creeping up on me. But no, thank you for watching from Shanghai. International audience, I'm very pleased with. And yes, Secret McSquirrel is tirelessly working away, providing you links. This is my secret channel, if you wish, Black Belt Secrets, where I discuss quite a lot of other things. Actually, it started out as martial arts, but now it's a whole range of different things, different issues, and sometimes giving my opinion on certain things that don't really belong on a law channel. So please do pop along and subscribe at Black Belt Secrets. And it's actually my older channel, albeit somewhat smaller now. This channel we're on here has dwarfed my original channel, but there we go. And the floof, the Black Belt floof, has got 1,300 subscribers. I'm blown away by that as well. I'm sure she'd be delighted if she understood what it meant. And that's this one here. But thank you, Secret McSquirrel. And hello from Wyoming. I'm pleased to have such an international audience here. And this one's at you, Al. All good. Might have some US environmental activists interviewing you if you. Yeah. No, I'm actually interested in this because the wig, albeit horsehair, I mean, not to be too blunt about it, but they don't exactly harm the horse to get the hair. So, what would be the? I know no animal products and all that, Al, for vegans, but the justification behind not wearing the wig, even though it's not really harming the horse, is there?
It's probably fair to say that, generally speaking, even among the sort of, there's quite an overlap. I know a lot of vegan barristers, although that's probably selection bias, and it's something that we've gone, but it's this whole thing about just there's the general exploitation of animals, even if there is no harm. Although we would all say, oh well, shearing wool thing can be quite nasty and dangerous. It's just because we use speciesist, unironically. So as far as we're concerned, it's using somebody else. I mean, there is this idea of what they call ahimsa products, which was very popular in like India, where it's what would otherwise be an animal product, but it's discarded. So like here's some hair that's just been we've just been brushing an animal and we've got this left over. Use something with it. And they also Louis Vuitton and all your big brands. They obviously want to sell leather handbags in India because there's a lot of very wealthy people in India. But there's culturally they normally can't use leather, but there's ahimsa leather, and that's like animals that have died of natural causes or been run over and things like that. Yeah. This is the whole vegan thing. Can you eat roadkill? We'll have to chat about that at some stage, but that is that's a real animal rightsy sort of topic about where the boundaries are and what is being done for practical reasons and what is really being done for more philosophical reasons. Yes, we accept that this doesn't actually individually harm an individual animal, but there's the sort of wider picture of using animals.
Yeah,
but yeah, we'll ramble on about that one day, and then just watch your viewer clicks suddenly just plummet as people go, "Oh God, it's the vegans." But because this is the whole thing. Because the whole thing about it's all about martial arts. I'm in Vegan Fight Club, and the first rule of Vegan Fight Club is you tell everybody.
Right. No, I get that. I do get that. I mean, it's a bit like the going green thing because I think once you decide to go green again, you tell everybody you should be, you should have an electric car, you should be on solar power, you should be doing this and doing that, and we're sort of in the middle of it at the moment. We've been planning it for ages, but we are definitely well and truly in the middle of doing all of that. And we're telling everybody about it for that reason. It is, it's been on my mind and it's been important for a long time. We've got to sort this out. We've got to sort this out. We've got to go. I mean, I've been with 100% renewable energy suppliers for years, and just now thinking, well, actually, now we've got to really go, 100%, and again, you tell everybody, but no. For those, the reason for that slight tangent was to really tell you all about a brand new channel, which I'm actually going to have to go and find the link for now. Let me see if I can find it by search yet. Media law, black belt barrister Robert Shaw. Let me see if it comes up in the search.
Oh yeah.
Yet. Yes, it does. Right. So now that I know that it comes up in the search, I can pop over. So you should be able to see this. Interestingly, when you search media law, black belt barrister Robert Shaw, this is the new channel. You can be one of the first, ladies and gentlemen. Only 57. You can be one of the first 100 subscribers here. We will be talking about art and media law and practically everything that comes under the different it keeps doing. I hate Safari, but it's the easiest one to share on this software. Not Easy Chinese Cooking, was it? Why is it giving me the wrong one? I don't know. Anyway, I'll get the link in a moment and I'll put it in the chat. So you can ask us any questions about copyright law, trademarks, all of this sort of stuff. So not limited to media and art, but all of that sort of stuff that doesn't quite fit with the same narrative here. I'm just going to try and refresh so it gives me the actual channel link, which it isn't. Al, what's your first video going to be about on this chat? I've got the link now. I'll put the link in the chat. Please go and subscribe. You're one of the first 100 subscribers to this new channel.
Oh, what shall we do? Well, I want to do, like I say, again, the aim is to do the practical law thing. So, and with all the sort of interesting trivial background that people seem to like. So I'm going to look at everything. We've got sort of things you need to know if you're starting a band or you're in the music business. I want to do a sort of basic overview of intellectual property for aspiring artists or even established artists. Just again, all the practical stuff, all the basics, how the thing works in practice. Because again, knowing the black letter law doesn't really assist you necessarily. It's like how do these things work in practice? How do you enforce copyright? Especially in an international world where a lot of it's digital. How do you stop sort of people sort of just putting all your stuff on websites and other things? So we're doing that. Do a little bit of history. One thing I want to do about interesting. I called it the legacy of Mark Rothko because there was loads of like interesting legal fallout there after he passed away. And things. And I shot the intro to that in front of a Rothko at the Tate, and they were really nice in that they let me do it right next to it, and you could see, and they actually filmed it, and you can see the worry as I was sweeping with my arm that they're going, "You're about to stick your hand through a like irreplaceable canvas." Truth is, I did the intro. That was like 2 years ago. Then the lockdown happened, and haven't done the rest of it. But yeah, it's going to be about sort of practical law for creative and media types, but also a little bit about just the history of it and some of the interesting cases over the years and interesting legal squabbles and disputes. Like Dean Koontz with his, Dean Koontz is the guy who does the balloon animals, and he tried to bring a copyright claim against anybody, and the judge just said, if anybody's got a copyright on balloon animals, it's circus clowns, go away. Which I thought was a great way of dismissing it.
And things to do with copyright and trademark, and here's one, can you trademark a color? You'll have to go and subscribe. The answer will be coming in on that channel, which is now in the chat for you to subscribe. At the moment, you can be one of the first 100 subscribers. You heard it here first. 78 now. That's jumped from 50. No. We've just had our 100th subscriber. Whoever that was,
yay!
whoever just subscribed, you are the 100th subscriber. Maybe we should get some sort of prize for you or something. Whoever that was that just subscribed, you are now the 100th subscriber. So that opportunity is now gone. But I had a ping for a super chat. That might have been one of you. Thank you so much. Thumper Z, if that is your real name, loves the way you say judges, Al.
Judges. I don't know how I say it. Judges. Oh, this is great. Is this like one of this? Is it ASMR thing where people go online to hear people pronounce things in certain ways? So I'll have to practice that. Judges.
Yeah. Do you know? There's something else as well. Now I've said before that to do with language, I love languages and the way people understand or misinterpret languages, and I think we'll leave you with this before we bore you all to death. But we'll leave you with these few anecdotes because we've just passed 2 hours. But I love the way language is understood or misunderstood, and couple of little points that came up recently. One of them is how you say a certain word is usually taken to be by all the professionals to be how you first learnt that word. And this is particularly prevalent if you're learning a foreign language, because you can learn a foreign language of like in a local accent or even local dialect in a certain way, and it may or may not be accurate, and it may or may not be local. And so when I was first learning Chinese, and I was over in China, obviously, with my dear wife, who is on Easy Chinese Cooking, by the way. So make sure you go and subscribe. I was talking in what I found to be a local accent. Or it was really a local dialect, but it might as well be a local accent. And so everybody was reduced to hysterics because of the way that I said something. And obviously I'm like, what did I say? What did I say? Thinking that I've said something really rude or wrong or something else. And it wasn't rude. It wasn't wrong. It was just it was merely the fact that it was in such a perfect localized dialect that I couldn't possibly have done if I tried otherwise. But that's how I learned to say it. So I just said it. And another way that came about, and this is all prompted by your super chat thumpers, so or thumpers, again, interpretation, thumper or thumper Z or thumpers, again down to the way that you learn something. So I say, you say, he said, they says. Is it says or says? The traditional way is says. Depending on what what they there's a traditional way, and there's what is now accepted internationally as says rather than says. So there's more than one person's commented on that just recently, and it's not just me. Politicians have been saying, says as opposed to says. I don't know which way do you fall, Al? Says or says?
I've mentioned before that I actually change. It's like code switching. I use different accents and different dialects and interpretations in different social situations, and a lot of that is subconscious. Like I say, when I was in London, my USP was I was a straight talking northerner. So I quite often, especially with juries, went a bit more northern than I generally am. And then down here, it was the opposite. I had to be proper London council and sound posher. But with says, I just said there says, but also I remember Les Dawson says Les, the programme. So I suppose it varies. I think part of it is it's just part of social interaction that you do sort of change a little bit depending on who you're speaking with and what circle, how you are. So, I mean, probably there's no doubt some social psychologists out in your very intelligent and learned viewership who could probably sort of chip in and know more about this than we do. But yeah, how language evolves is very interesting, and stuff, especially in like the law where words get frozen in time. Like why malice means different things in different contexts depending on when the key case was designed. Yes, scones and scones. That's the other.
Yeah, no, absolutely. I find that fascinating. So, finally, yes, there's no, absolutely. No, I agree with that sentiment entirely. Let me jump back to that again. I like that idea. Given that there's over 1,000 of us in here, there should be over 1,000 subscribers on here. We were over 100 already. Let me refresh and see what it comes back to now. That's assuming that everybody wants to hear more from us, of course. 112, not quite 1,000. But anyway, those of you that were here, somebody just down voted the video. Obviously didn't like what I said. Never mind. As I said, not everyone's going to like everything that I say. I'm a lawyer. That's my excuse. But no, I thank you all for your time and your patience, and Al, particularly thanks to you as well for joining in, having the chat with us. It's been fun. It's been informative. It's been it's been far-reaching. We've had a few different tangents. Just scanning through the last.
Hopefully, it's been completely compliant with all injunctions and court orders. Otherwise, next week, our special, what's it like on D-Wing?
Yeah, absolutely. Well, hopefully we've dodged all of those bullets before they were fired. But I don't think there's any problem there. So no, thank you all very much for watching. Thank you for your time. I'm always sorry to leave any audience, let alone well over 1,000 of you. So thank you all for your kind attention and your time. Check out all of the channel links that we've talked about. They're all there. We try to bring you as much content as possible. They're all linked in the descriptions to the videos. And with that, we'll say thank you very much, and have a great rest of the day, everybody.
Adieu.